Hey guys, welcome to installment number 3 of Business Law Lectures. I know you guys are super pumped to have another lecture. I'm coming to you live and in person from my garage today. It's Sunday. It's a beautiful day in Elkins, West Virginia. I hope you guys are all doing well, staying at home, doing all the things that you're supposed to do, not doing any of the things that you're not supposed to do. So today, I want to talk about two things. First, we'll finish going through our 4 elements of a valid contract. We've gotten through agreement, consideration, capacity, and now we're going to move on to legality. And then we'll switch gears and talk about the statute of frauds. You've heard me mention before that the statute of fraud details the types of contracts that have to be in writing in order to be enforceable. Excuse me. So let's start with legality, the final element of any valid contract. In order for a contract to be valid, and remember, a valid contract can be enforced by both parties to the contract, the goal of the contract, what it calls for each side to do, has to be legal. It can't be illegal. If the goal or if the purpose of a contract is something illegal, then that contract is void. And remember from our discussions concerning capacity that a contract that is void is unenforceable by either party. Contrast a void contract with a voidable contract, which one party to the contract can get out of, a valid contract, which both sides to the contract can enforce, and a void contract where neither party can enforce. So, if a contract calls for anything illegal, it is void. So, for example, if I hire someone to kill someone else, murder for hire, a hitman contract, and the hitman performs his or her end of the bargain and kills the person I've requested them to, and I don't pay him the money that I've promised to pay them, they cannot enforce that contract. They can't go to court and say, he owes me $10,000 for killing so-and-so. And that's pretty obvious. Nor do I think would anybody run to court and admit to murder in order to collect on a contract. So it is kind of a silly example. But under that example, neither party to that contract could enforce it. Now, I can give you some examples of a little more real-world type example that illustrates that contracts that call for something illegal are void. So let's say my friend says to me, hey, I got to get to Morgantown. I got to be there in an hour. Can you take me? And I'm like, sure, I'll take you to Morgantown, no problem. On the way there, he's like, hey, man, can you speed up? I'm like, hey, I don't want to get a speeding ticket. And he says, listen, if you speed and get me to Morgantown on time, I'll pay any ticket that you might get if you get caught speeding. So predictably, I get caught speeding. I get a ticket. It costs me $150. I say to my friend, hey, you owe me the $150 to pay the speeding ticket. I speeded per your request. And now you're contractually obligated to pay my speeding ticket. And he would not be contractually obligated to pay my speeding ticket because what he asked me to do, what I agreed to do, and what in fact I did do, speed is illegal, and therefore that contract is void. So, an even better example, and this is oftentimes something that a real world example of illegal contracts being void. Each state sets the maximum amount of interest that can be charged with regard to certain things, say consumer loans, credit cards, things like that. Every state's a little bit different, and I want to say it's North Dakota or South Dakota that imposes basically no limits, and that's why you see a number of credit card companies headquartered in those states. So anyway, states set the maximum amount of interest that can be charged with regard to certain things. And you'll see this pop up with these payday type loan places, where you go in and as long as you have a valid pay stub, they'll lend you money. But if you don't pay within the first week or two, or whatever the terms are, then the amount of interest charged increases, sometimes exponentially. And so states put limits on the maximum amount of interest that can be charged. So occasionally you'll see situations where somebody borrows money, is charged an exorbitant and illegal amount of interest, more interest than's allowed by state law, and those contracts call for something illegal. They call for a maximum rate of interest that is greater than the maximum amount allowable by state law, and those contracts will be void. Okay, that's legality in a nutshell. Look, on a question, on a test or something like that, I'm likely to give you the hitman example and ask you whether the contract is void, valid, voidable. Just make sure anything that's illegal, you put down it's void. Do not, I always get a few people that answer this question that the hitman contract is a valid contract. My goal is nobody gives me that answer this time around. Remember, contracts that call for illegal acts are void, unenforceable by either party to the contract. Okay, so let's move on to the statute of frauds. And we've talked a little bit about how an oral contract is just as valid and enforceable as a written contract. And that's true with the vast majority of types of contracts. The statute of frauds gives us a list, essentially, of all the types of contracts that have to be in writing in order to be enforceable. Let me digress for just a minute. And again, I've told you repeatedly that oral contracts are enforceable, but I want to give you a caveat there. Obviously, a written contract is much easier to prove than an oral contract. An oral contract made between two people with no witnesses comes down to the word of each of those parties to the contract. So you might have a situation, and it's not uncommon, for one person to claim, well, these were the terms of the contract, and the other side, no, the terms were different, or we had a contract, and the other side says we didn't have a contract, and it basically comes down to one person's word against another. Now, if you're looking to prove something in court, that's not the best way to do it. Obviously, a written contract signed by both the parties is much easier to prove that there was a contract and what the terms of those contract and what the terms of that contract were if you have a writing, okay? And as we get through the statute of frauds, you'll see that there are certain types of things that the writing that's required isn't some huge, long, 100-page contract that deals with every possible situation that could arise. Oftentimes, a written contract can be a series of emails back and forth that show what the agreement of the parties were. And all of those emails or text messages or writings taken together can form a written contract. Now, if you have an oral contract and there are numerous witnesses to what the bargain was, what the terms of the contract were, that would make an oral contract easier to prove or easier to enforce. But again, I want to make that point that obviously a written contract is easier to prove, both the terms and the existence of a contract, if it is in writing. Okay, so under the statute of frauds, and I won't go into a detailed history of the statute of frauds, but it's been around for quite a long time. It comes from our old English common law tradition, and it's been codified by most, if not all, of the states. And when I say codified, I mean the state legislatures have made statutory law that makes the statute of frauds the law of the land. I'm sure there's differences in each state, but these are the main, basically 5 types of contracts that have to be in writing in order to be enforced. The first is a contract for any interest in real estate. Okay? So any type of contract that calls for the sale of any interest in real estate has to be in writing in order to be enforced. So the most common example would be I enter into a contract to buy a home. That contract for the sale of a home, again, real estate, has to be in writing in order to be enforced. That's the easiest example as far as any interest in real estate. You go to buy somebody's house, you enter into a contract with them, and calls for you to close on a certain date, the purchase price, various other elements that go into a contract when you buy somebody's home. That is the most common interest in real estate. But there are a number of other interests in real estate that also have to be in writing if there is a sales contract. So, for example, a mortgage is an interest in real estate. In West Virginia, we call it a deed of trust. But essentially what a mortgage is when you borrow money to purchase a home or some type of real estate. And the bank, the lender, takes an interest in that real estate. In other words, you get a deed to the property, you get a deed to your home, which is the instrument that transfers ownership from the previous owner. But the bank, the lender, takes a mortgage on that property. And I'm going to oversimplify here, but essentially what that means is the bank, the lender, retains that interest in that real estate so that if you violate the terms of making your payments of your loan, you don't make your loan payments, or you don't keep the property insured as you're supposed to, then the bank, the lender, can come in and force a sale of that real estate. And that, a mortgage, is an interest in real estate, and therefore a mortgage has to be in writing in order to be enforced. There's something called a life estate, which is an interest in real estate. And a life estate is when, let's say, grandma has some property and she wants it to go to her grandson. And she wants to go ahead and give it to that grandson now so it doesn't have to pass through her estate. In other words, when she dies, she could leave that real estate to her grandson in her will, but she wants to go ahead and get that taken care of now, but she wants to be able to stay on her property or stay in her house until she dies. And therefore, she can deed away her property, but retain a life estate in that property, which means that the real estate essentially remains hers up until the day she dies, but immediately upon her death, it transfers to the grandchild or whomever she chooses to have that land when she dies, and that way it doesn't have to go through the estate. A life estate is what she reserves to herself. If somebody has a life estate in a piece of property, it means they get to stay on the land and reap the benefits of the land for as long as they remain alive, but as soon as they die, it passes to the person they've designated. So a life estate is an interest in real estate, and to transfer that, it has to be in writing. I don't want to get too much into the various interests in real estate. Mineral rights, gas rights, these are all interests in real estate. So we talked a little bit about how, for example, I own the surface of 2 acres where my house is, but I don't own the minerals or the gas or oil that may be below my house. Somebody else owns those mineral rights. And if they want to sell those mineral rights, that's an interest in real estate, and that contract has to be in writing in order to be enforced. Okay? So number one, under the statute of frauds, contract for the sale of any interest in real estate. Number two, a promise to pay the debt of another has to be in writing in order for it to be enforceable. So if, for example, I, as the parent of a college student, sign a promissory note saying, I will pay my child's tuition if they don't pay it, or as a co-signer, in order for that promise to be enforceable, it has to be in writing. That contract has to be in writing. Now, I don't want to get too much into the intricacies, but you might question, well, how is there consideration for the promise to pay the debt of another? And without getting too far into it, sometimes contracts are made for the benefit of a third party. And that third party is allowed to enforce that contract as what's called a third-party beneficiary. I think I'll stop there with regard to that, because we could go on for quite a while on third-party beneficiaries. But in any event, if I make a promise, for example, to Davis Elkins College to pay the the tuition of my adult daughter or my adult son. That promise has to be in writing in order to be enforceable. So if you show up at the college on day one and mom says to the college, don't worry about it, I'll pay his debt, the college needs to get that promise in writing, and hence you see that typically what they'll do, or what they used to do, was have the parent sign a promissory note, and then they have that obligation in writing, and it can be enforced. Oh, my cat just showed up. You guys want to see my cat? Come here, Carlos. Say hi to Carlos. Hey. Sorry, a brief moment of levity. Okay. The next type of contract that has to be in writing in order to be enforced is a contract for the sale of goods worth over $500 under the Uniform Commercial Code. The Uniform Commercial Code, or UCC for short, is basically a body of law dealing with all sorts of commercial transactions. And every state has adopted this Uniform Commercial Code so that there is a uniform set of laws dealing with commercial transactions that every state, I think with the possible exception of Louisiana, has adopted. And the reason for wanting to have a uniform body of law with regard to these types of transactions should be obvious. You don't want to have to go and research what the law is in all 50 states just to figure out how to do your deal in one state. Very few things are confined to the borders of one state anymore. Just about anybody that does any type of business is going to do business with some company out of state, whether it's ordering restaurant supplies for your restaurant, from if you've got a restaurant in West Virginia and ordering supplies from an outfit in Pennsylvania or something like that. So we have this Uniform Commercial Code, or this UCC, that deals with all these transactions. I think perhaps Louisiana has not adopted all of the UCC, and that probably has something to do with the fact that as a former French territory colony, it adopted large portions of the Napoleonic Code, and my guess is that may be why Louisiana is a little bit different than the rest of the country. It's not important to the class, just a little diversion there. So anyway, contract for the sale of goods worth over $500 has to be in writing in order to be enforced under the UCC. Now, the type of writing that's required under the UCC is what we talked about a little bit earlier. It's not necessarily this big, long contract that spells out everything. The UCC will deem communications between the two parties contracting with each other, emails, texts, other writings that go back and forth, will be sufficient to form the basis of the contract. So, if, for example, you order you're a restaurant in West Virginia and you order $5,000 worth of pre-printed menus from an outfit in Oregon, and you've emailed back and forth, hey, I want these types of menus, they're to be this color, they're to have all this information on it, and the menu publishing company emails back and says, that's great, we've got all your specifications, we're going to charge you $15 per menu at a total of 5,000 menus for, you do the math, however much money that is. They email that back. That's going to be a sufficient writing to form the basis of the contract under the UCC. It's not one contract that both sides have signed and is notarized. It's two or three or a series of emails going back and forth that detail the essential terms of the contract, right? And remember our three essential elements of a valid offer. So all these emails taken together show what the contract was and will be a sufficient writing under the UCC. Two texts. Hey, Richie, I'll sell you $750 worth of widgets for and I can have them delivered by Tuesday if you get me the $750. I text back and say, I accept your offer. I will expect the delivery of the 750 widgets or the widgets for $750 by Tuesday. Thank you. Those two texts taken together will probably be a sufficient writing under the requirement of the UCC that the sale of goods for over $500 must be in writing in order to be enforced. Okay, that's the second one. The third type of contract that has to be in writing in order to be enforceable is a contract in consideration of marriage. Now, what does that mean? First of all, we could digress for a minute and we could say, think of marriage as essentially as a contract, right? Each party is agreeing to certain things, and if one side breaches one of those things, it forms the grounds to dissolve the marriage. Now we have no-fault divorces, but it used to be that you had to prove some type of fault, either adultery or something like that, in order to get divorced. We don't have that so much, but it's a useful example to think of marriage as a contract. Now, what would be a contract in consideration of marriage? In other words, a contract in which if you do something, we'll get married. And what we're talking about here are prenuptial agreements. Prenuptial agreements are contracts between the two people getting married that they're contracting for what will happen, typically financially, although people have prenups about who gets the dogs or things like that. What will happen financially if the marriage results in divorce? And typically you see prenuptial agreements entered into where one of the people getting married has significantly more resources, money, than the other. So if, for example, I were marrying a rich and famous actress, I know there's absolutely no chance of that, but if I were marrying a rich and famous actress, and let's say she's worth $100 million, and I'm worth $200,000 as far as total assets are concerned, she may very well present me with a prenuptial agreement to protect her assets in the event of a divorce. She makes a lot of money. So typically in most states, marital assets, and I don't want to get into what's a marital asset and what's not a marital asset, that's not important for this class, but marital assets are divided 50-50. So my rich Hollywood fiance wants to make sure that if we get divorced at some point down the road, that I'm not going to take half of her assets which she's acquired during the course of the marriage, because she makes a lot more money than me. Or she might have children from a previous relationship, and she wants to protect her assets so that her assets go to her children one day and not to her West Virginia lawyer ex-husband. So the prenup might say, okay, well, if we're married for 1 year, you get $500,000. If we're married for 2 years, you get $1 million. It might be a sliding scale, something like that. Married for 5 years, you get $5 million. It can say whatever the parties want it to say, whatever they contract. But in order to be enforceable, it has to be in writing. And that is strictly enforced in the family courts of this country. You can't go into court and say, at your divorce hearing, and saying, hey, before we got married, we sat down, we talked about it. Richie agreed he didn't want anything if we get divorced. And that was our agreement, so court, you should enforce it. Court's not going to enforce that, because that prenuptial agreement has to be in writing in order to be enforced. And again, that's a pretty strict requirement with regard to prenuptial agreements, because the law presumes something else. So if you're going to go against that presumption, you've got to get it in writing in order for it to be enforceable. And prenuptial agreements are relatively standard. They need to be carefully drafted. And each side, before signing, typically there's a requirement that they have at least the opportunity to consult with an attorney to explain to them what the ramifications of that prenuptial agreement are. Again, contract in consideration of marriage boils down to a prenuptial agreement, has to be in writing in order to be enforced. The next type of contract that has to be in writing in order to be enforced is a contract which will take more than 1 year to fully perform. So if by the very terms of the contract it's going to take more than a year to fully perform, and again, when I say performance, I mean do what you're supposed to do under the terms of the contract. If what you're supposed to do is by its own terms, definitely going to take more than 1 year, then that promise needs to be in writing. That contract needs to be in writing in order to be enforced. So, for example, a 2-year lease agreement can't be fully performed in 1 year, and therefore a 2-year lease agreement needs to be in writing in order to be enforced. An employment contract for more than 1 year has to be in writing in order to be enforced. Let's take a minute and just talk about employment contracts. It's probably a good opportunity to do this. I'm digressing a little bit, but the vast majority of employees are what we call at-will employees, which means that they don't have an employment contract, and they can be fired for a good reason, a bad reason, or no reason at all. Now, there are important exceptions to that. Obviously, if an employer fires somebody because of religion or race or gender, those are protected categories. So you can't fire somebody for those and a few other reasons. But other than that, an at-will employee, an employee who doesn't have an employment contract, can be fired by their employer anytime. And the employee can quit, right, without fear of consequences. So I can be fired at any point, but I can also quit at any point. Now, people say, well, you need to give 2 weeks' notice. Well, that's always the right thing to do, but there's no legal ramifications if you just walk off the job as an at-will employee. So, but some folks do have contracts of employment. And then whether you can be fired or whether you can leave that employment are governed by the terms of that contract. So you might have a contract with an employer that says you agree to work here for 5 years at this rate of compensation, and you can only be fired because of a host of detailed reasons, not doing your job, malfeasance, things like that. And you can't quit either. I mean, you can leave, but you could be sued for breach of contract, right? So if I have an employment contract and I'm fired without cause as detailed under the contract, then I can sue. If an employee leaves before that contract is up, they can be sued. And when we talk about contractual damages, in other words, what type of money you can get under a breach of contract case, we'll look at an employment law example. So, an employment contract that can't be fully performed within 1 year, in other words, a 2-year or a 5-year or a 10-year employment contract, all of those types of contracts have to be in writing in order to be enforceable. Now, some types of contracts may look like they can't be fully performed within 1 year, but in reality they can. So, for example, if I'm hired to work at a convenience store and I have an employment contract, and the terms of that contract are you agree to be employed at this business for as long as the business remains open. Now, under that example, could the contract be fully performed within 1 year? And the answer is yes. Technically, it could, because there's no guarantee that the business will last an entire year. So if the business goes under in the first 8 months, 10 months, 11 months, that contract has been fully performed in less than 1 year. So it's not, is it likely that it can be performed within 1 year? It has to be if there's no way, if it's impossible for it to be fully performed within 1 year, then it has to be in writing. So again, with the example of you're employed here for as long as the business remains open, might not remain open for a year. So technically that contract need not be in writing to be enforced. Again, I'll reiterate the point I made at the beginning of the video, which is obviously it's much easier to prove the terms of a contract when they're in writing and they're spelled out and signed by both of the parties. I mean, oftentimes you have disputes about what a particular provision in a contract actually means, but it's a lot easier to show what the terms are and the overall existence of the contract if in fact it is in writing. Okay, let me see. Contract for the sale of real estate, promise to pay the net debt of another, contract for the sale of goods over $500 under the Uniform Commercial Code, a contract in consideration of marriage, and a contract which will take more than 1 year to fully perform. Those are the 5 types of contracts that have to be in writing in order to be enforced under the statute of frauds. That's probably a pretty good place to end today. We've got just about a half an hour. Again, if any of you guys have suggestions about how we could do this remote stuff any better, I am very much open to your suggestions. I'd love to hear from you guys. Shoot me an email. Tell me what you think. Thus far, I have no problem with constructive or even not so constructive criticism. At least it lets me know you're watching these things. I really hope you're getting something out of it. It's difficult for me to do these lectures online because, as you guys are aware, I like to ask you questions. I like to prod you a little bit. I like to get your input. So anything that you have to say about this, good, bad, mean, nasty, I don't care. I'd appreciate it. Shoot me an email. Leave something in the comments. Anything to let me know you guys are at least paying some attention to these videos and hopefully getting something out of the class. And again, if you're unsure about something, if I've confused you with the lecture, give me a call or shoot me an email. It's never an issue, never a problem. It seems like everybody's looking at them. I think I'm going to be able to report to the college that everybody's participating. I got to go through the comments again on Monday. I really hope all you guys are weathering this storm as well as you can. I know we have some international students. I hope you guys are okay. You have a good place to shelter, for lack of a better term. If there's any way I can be of assistance to any of you guys stuck in Elkins, if there's anything I can help with, please let me know. I'll do everything I can to help you out at this point. So, all right, I will sign off for now. I'll do another lecture probably Tuesday, and I think what we'll do in that lecture is we'll go over the assignment that is due Monday morning at 9 a.m. That would be the 30th of March. It's my wife's 49th birthday. And I'll have a whole lecture, or at least part of the lecture, going over the answers to those questions to make sure you guys understand everything that's going on. All right. Take care of yourselves, and hopefully I'll talk to you guys soon. Bye.